Citizen suit, for those of you that don't know, a citizen suit, and which is basically the same thing as what I'm referring to as private causes of action. Citizen suit is a legal action brought by citizens under a provision of an environmental law that gives citizens a private right of action. As Jamie pointed out earlier, if there's violations under the Coastal Act, the government can come in and force somebody to change something or fine them or do all that. Citizens can do it too. Another interesting thing about this act as compared to other environmental laws is standing. Standing, for those of you that don't know, is a procedural requirement that a party has a sufficient connection to the harm from the law or action challenged to support the participation in the case. Coastal Act defines this really amazingly, if you do what I do. Any individual, organization, partnership, limited liability company, or other business association or corporation, including any utility in any federal, state, local government, or special district or agency, anyone can file an action under this law. And you don't need standing like you hear about in the environmental world to do this. Let's talk about the remedies. Under the Coastal Act, under a private action by a citizen, you can get two kinds of things: civil fines and penalties, and what we call injunctive relief and declaratory relief. Those are, the first one's easy to understand. You violate the act, you have to pay monetary fines. The second one is where you're asking the court to force somebody to do something like remove the fence that you put there illegally, or restore some environmental condition that you've changed. Both of those are available under the Coastal Act. There's two kinds of fines, and I'm going to try and discuss the differences between them in a second here, but the basic one is civil liability may be imposed by the Superior Court in accordance with this article on any person who performs or undertakes development that is in violation of this division in an amount that shall not exceed $30,000 and shall not be less than $500. Civil liability may be imposed for any violation of this division other than that specified in paragraph 1 in an amount that shall not exceed $30,000. So, I think that's pretty straightforward. The second one is where the act is done knowingly. And this is a pretty big thing here. Any person who performs or undertakes development in violation of this division, when that person intentionally and knowingly performs or undertakes the development in violation of this division, may, in addition to any other penalties, be civilly liable in accordance with this subdivision. Civil liability may be imposed by the Superior Court in accordance with this article for a violation as specified in the subdivision in an amount which shall not be less than $1,000 nor more than $15,000 per day for each day in which the violation persists. Think about those numbers. And we're going to talk about those with respect to my case against San Francisco. Minimum $1,000 a day for a known violation. And again, this money, as Jamie pointed out, doesn't go to clients here, whoever we would represent. It goes to the state, but it's an awfully big hammer to try and force somebody to comply. Let's see. And this is what I just said. It goes into the violation remediation account of the Coastal Conservancy. For the lawyers out there or the law students, this is important how you draft settlement agreements, where you want that money to go. If you have a nonprofit that has paid you to prosecute some kind of an important interest, you don't want the money going to the state. You want it to go back to your little nonprofit that did some public good. So watch how you draft settlement agreements. So in just summary, private enforcement actions, there's few procedural requirements under the statute. The standing we talked about, notice, you don't have any notice requirement under RCRA and all those other kind of laws. You got different types of notice that you have to give before you proceed. Argument I'm in with the lawyer for the city of San Francisco is, do you have to comply with the Tort Claims Act? I don't think you do. We won't go on a tangent about that, but generally the Tort Claims Act says under certain types of lawsuits you have to notify the government of them before you bring them. And that's not just torts, those are breach of contract and all kinds of things. I don't believe they're the Coastal Act, though. We talked about, we didn't talk about it, but scienter is a concept in the law that basically says you did something knowingly. You don't have any of that requirement under the Coastal Act unless you're going to get into the civil penalties that are, you know, the more extreme ones, $1,000 per violation. Interesting, you file it like any other lawsuit. You know, if you look in the pamphlet, I got the cover page, the one that Mark Nassar and I have filed. It's just like a normal lawsuit. No need to join the Coastal Commission. I won't get into detail, but it's probably a good idea to send a copy of the complaint to the Attorney General.